Hey y'all, it's Denise here again with braiderscourse.com, where you can get your her braider certification that'll last you a lifetime for $199.99 and protect your business and legitimize your business to keep yourself from being inspected, right? So we offer inspection protection as well as legitimizing your hair braiding business for all these haters out there so you won't be getting sued like this young lady here in Texas. I decided to come on here and show y'all because everybody always sugarcoating that yeah, you could open your own shop and yeah, you could do this and you could do that. Nobody want to get on here and tell y'all the real deal of how these white supremacists as boards of cosmetology and boards of barbers gonna come after you. And if they don't come after you, you're gonna have some old weird ass client that's gonna go and get them a lawyer and come after you. So excuse me, y'all. Let's just get into this whole thing. As y'all know, again, I'm Denise Jarrett with braidiscourse.com, and I just want to help her braiders legitimize their business. I'm a licensed cosmetologist, okay? So I have to follow the cosmetology rules. However, the barrier has been lowered for entry to get into salons, and that's why I went out on my way to help her braiders legitimize their business so they could be out here without the government being in their life. Now, this is a court case that, as you can see, this is a 2022 court case. All right. This court case was filed February 14, 2022 at 7:51 a.m. All right. Right here, the top part, filed there. Crystal Bell and is versus Crystal Bell is the young lady that went in and sued. She versus Tamia Swanson, TBA True Stylist Exclusive Salon. Now this is in Texas. The honorable judge of said court. Okay, so this is, I guess, in the county might be, no, it's Harris County, but I don't know why they got said court. Now comes Crystal Bell, hereinafter called the plaintiff, and files an original petition to request the disclosure of the complainants of the defendants complaining of and about Tamia Swanson, True Stylist Exclusive, for the cause of action shown in the court following. Now, this is the discovery. The plaintiff intends to conduct the discovery second level on Texas rules for civil procedure. Now, this is not criminal court. This is civil court. This is why I'm telling you, you have to legitimize your business because they're going to take you to civil court and your ass going to have to be ready. All right. It says the jurisdiction and venue. So that means they have to make sure that they're in the right space and the right place to take you to court. So the jurisdiction is proper. This court because the amount in the controversy exceeds the judicial minimum of this court. And venue is proper in Harris County because the incident that was made in the basis of the lawsuit occurred in Harris County. So maybe whatever county your salon is or wherever you working at, or if you a home-based business, you leave and go to their house, they gonna sue you in their county. Crystal Bell is the plaintiff, the individual residing. This is her address in Texas. Now all this stuff becomes public information. All right. So when you out here getting in, yeah, you know how to do her because your mama and them taught you, your cousin and all this, but you don't know business. So you have to legitimize your business because your mama ain't taught you business. All right. So you have to legitimize your business because this woman put her address out here and telling you she coming. Okay. Upon information and belief, the defendant, this is the hairstylist, Tamia, is a Texas partnership with the principal place of business right here on Texas, in Houston, Texas. Tamia Swanson, the defendant, is the individual and her residence is unknown. So because she was a hair braider, they don't have no no record like the state would normally keep a record of people. They don't have a record of where she stayed, but they know where to shop at, so they still came to it. All right. At all times mentioned in the petition, defendant Tamia owned and operated this salon, beauty salon. Beauty salon is at this address located in the shopping center on or about February 15th of 2020. So this person waited 2 years. See, okay, so it might be the statutory redemption timeline, because this why he hurry up and filed it on the 14th of February, because otherwise it would have been a 2 year, okay? But this person waited 2 years. So on and about February 15th, the plaintiff sustained severe head and scalp injuries, hereinafter described as direct and proximate results of the negligence of one or more of the defendants while visiting this salon, right? During the course of the plaintiff receiving what she called a hair wash, set, and weave installation during her hair appointment, the plaintiff experienced a swollen scalp that was red and tender to touch. Okay, the defendant installed the weave into the plaintiff's hair without treating or cleaning the hair. So, how did you get there to do a hair wash, but hey, you didn't get the hair cleaned at all? So, this is the argument over can a hair braider have shampoo, all of this stuff. As the plaintiff was under the hair dryer, the hair weave in the hair weave installed, she began to feel a tingling sensation similar to relaxer on her head. Now, so she know what a relaxer feel like. So she feel the burning with the hair weave already installed. I don't even know what happened here. Okay, the defendant told the plaintiff she had a soft scalp and it would be fine. So the hairstylist is the one that told the plaintiff that you got a soft scalp, you'll be fine. Over the course of the few days, the plaintiff head began to burn increasingly worse. The plaintiff contacted the defendant to see if she had done anything different to her hair than her last appointment. So this means she go to this woman often. She informed the defendant that her scalp was now forming pus pockets, okay, along with the intense burning. So you know how your hair could be pulled so tight you get them little pus bumps and you get the pus pockets, then it's gonna all be a scalp. Okay, so the defendant told the plaintiff that there was no way the plaintiff was experiencing was a result of her visit and dismissed the complaints. All right. When the plaintiff contacted the defendant, she threatened the plaintiff with threats of force, which such as I am just not trying to go to jail before I beat your ass. Now this is what she told the lady. Okay, when the Crystal contacted Tamia, when Crystal contacted Tamia, she threatened Crystal with threats of force, such as I'm just not trying to beat your ass. The plaintiff went back to her previous hairstylist to see if there was anything that could be done about her head. The previous hairstylist confirmed the pus and open sores on the on the plaintiff's scalp. Now she just confirmed these things because guess what? She knows she wasn't supposed to touch him, I hope. All right. The following Tuesday, the plaintiff woke up in tremendous pain on her head and in her shoulders, resulting from the tightness and stiffness. So really what it was her head and shoulders because she couldn't lay right. So she might got a crook in her neck and shoulders because that head was so tight you can't even lay right. She asked her daughter to look at her scalp, and her daughter noticed an inflamed scalp, now with blisters and more swelling. She also noticed the rash spreading to her face. Now, she already got threatened to get her ass beat. Why in the hell did she keep that shit on her fucking head anyway? She should, and she already done went to the beautician, and the beautician is seen like, girl, you got to do something. She should have went to the doctor. She wasn't supposed to be going to no daughter. She should have went to the doctor and the fucking police, because the bitch didn't already threaten her. Then it goes, the plaintiff went to the Pearland urgent care where they diagnosed her with severe scalp infection and fungus after the treatment of medication for 60 days now. So she gets 60 days, plus she been to the doctor, plus she about them ain't been to work, plus she got to pay for the other stylist just telling her she's seen it, and the daughter, oh, she want a lot of money. Okay, the plaintiff was informed that she would have permanent alopecia as a result of the infection and fungus. So she get a scalp prosthesis forever because you done permanently gave this woman alopecia areata and bald her. Okay? The plaintiff currently has permanent hair loss with less than 10% chance of ever regaining her follicles in many of her head. So I mean, I guess it must be in follicles in many spots of her head, because this girl that messed up. Now here go the negligence. All right, the occurrence made the basis of the suit, and the result of the damages and injuries were approximately caused by the negligence conducted by the defendants in one or more of the following respects: by the salon operating in conjunction with another facility without proper separation. So maybe she got something else in there and talking about this a salon and ain't even separated it. Um, could be uh facials, could be anything, eyelashes, even feet care fungus. Okay, all right. By failing to properly clean and disinfect equipment, implements, and materials properly, by providing services. Exactly, you ain't never even cleaned that needle. This is why over here we argue about the needle and cleaning it. Fungus ain't all she got. She could be and got one of the H's out of the 5 H's we talk about. Herpes, remember the H's? Herpes simplex 1 and 2. All right. HIV, right? HPV, right? So these ones could be out there. All right. By using a product, preparation, or procedure that came in contact with, penetrated the dermis layer of the skin. So that's just what she, or penetrated the dermis layer of the skin. So this is what they talking about where the needle stick came. See, using a product, preparation, or procedure. So the product was the hair, preparation was how she installed it, the procedure was the needle and stuff she used that came in contact with or penetrated the dermis layer of the skin. So you can't penetrate or pierce the dermis layer or the epidermis when you are sewing in these weaves. I'm telling you, by failing to clean or disinfect her products as required, by failing to follow standard Texas health and safety guidelines. Each of these acts and omissions, singularly or a combination of others, constituted negligence that proximately caused the occurrence that made the basis of this action and the plaintiff's injuries and damages. Okay? And then they go on into the damages. Okay? Now, the damages for the plaintiff. By reason of all of the above, the plaintiff suffered losses and damages in the sum within the jurisdiction limits of the court, and for which this is a direct and proximate result of the occurrence made and the basis of the lawsuit. The plaintiff suffered pain and suffering and mental anguish. Okay? She both suffered job loss, all kind of stuff, 60 damn days. All right? As a direct proximate result of the occurrence that made the basis of the lawsuit, the plaintiff incurred the following damages: reasonable medical care and expenses in the past and future. These expenses are incurred. So that means she still got to go to the doctor. So this woman probably want $100,000 or something. I'm telling you. Plaintiff for the necessary care and treatment of the injuries from the incident complain of herein and such charges and responsible and were and customary charges or such services in Houston, Texas. Okay. Physical pain and suffering from the past and the future. Mental anguish from the past and the future. So they want her to go back and forth, right? For the past and the future, which I really don't agree with because she knew that this was going on when she went the first time back to her and when she went to the stylist before she took another week and asked her daughter, then asked the urgent care. No, no, no. Okay, the prayer. Wherefore, plaintiff requests the defendants be cited to appear and answer that the on the final trial plaintiff has a judgment against the defendant and the sum within the jurisdiction of the court, prejudgment and post-judgment interest as provided by law, cost of the suit, so the lawyer want his money, such other and further relief to which the plaintiff may be justly entitled. Signature page follow. Now this is Yancey Legal Group, okay? Jason Yancey. This is state board number. This is who he is. He is the lawyer for this young lady, Crystal, that is suing Tamia. And as you can see, they want past and future money. So they want the money from her losing work, the money for the hair weave, which we know the weave itself could be up to $1,000. Then she could have charged her for the install, which could be like another $1,000. Then she want to say she made an appointment with another hairstylist that told her the scalp was on her. Plus you got to pay for the lawyer that's filing this stuff. So this is a whole big argument. Like I said, it happened in 2020 and now it's just not getting to court in 2022. I don't know if it could possibly be struck down by it being a statutory time over the limit or what it may be. But as you can see, I just wanted to come to all my hair braiders and let them know that this is not a game. I'm not just out here trying to sell you something. I have made it to the lowest point that you can have to make sure that you get hi, good morning, Turquoise. I'm over here looking at this thing. I normally just be not even talking to my people. I just be talking out here. But good morning. Hey, I love you. All right, cousin. I love you so much for backing me with this hair braider thing. But yeah, I just want everybody not to be in the predicament that this young lady is in and being sued. With their business. So you legitimize your business. That way she can't get 3 times the damages. She gonna get 3 times the damages of buying the hair weave, getting the hair weaves installed, going to the doctor, going to the other hairstylist, paying her daughter to take it down, and 60 days of having to keep on applying this treatment. Plus she want in the future mental health money, you know. So I just want y'all to protect y'all business. I came to y'all to help y'all so y'all can protect y'all business from everybody being able to sue y'all. By us being hairstylists with the state, they can sue us, but they won't get 3 times the damages as long as we in an association and we have a license. With you all, they'll get 3 times the damages and maybe more. So that house you done bought, that car you done bought, or whatever you done bought your kids, they'll be trying to attach themselves to it. Okay, so again, I'm Denise Jarrett with braiderscourse.com, and I just wanted to come to y'all because nobody is showing y'all this. They telling y'all, yeah, about the Crown Act and you free to wear your hair, but they ain't showing you that they setting you up to go to jail or lose your assets because you don't have the proper paperwork in place to be running no business, even though you are in business and taking money in commas. So if you want to talk to me, give me a call at any time. My phone number is 612-407-2824. It's everywhere. And again, I'm Denise Jarrett with braiders course.com and Mo Her. Bye.